Our final panelists are Lauren Jorgensen, is that right?
Yes, sir.
Christine Lucius, is that right?
Yes.
And Heather Rice-Minus.
Minus.
Ms. Jorgensen serves on the Board of Directors of the National Association of Assistant U.S. Attorneys and chairs that organization's sentencing committee. She has been an assistant U.S. attorney in the Southern District of Florida since 1990, specializing in white-collar crime. There's a bit of that in the Southern District.
A little bit.
Before that, she was in private practice in New York City. Ms. Jorgensen is a graduate of Cornell Law School. Ms. Lucius is Executive Vice President for Policy at the Leadership Conference. She has worked in all three branches of the federal government, including 14 years with the Senate Judiciary Committee as then Chairman Leahy's top legal and policy advisor. I should say it's the Leadership for Conference on Civil and Human Rights.
Thank you.
In 2015, she was named by the National Journal as one of the 20 most powerful women staffers on Capitol Hill. Before working for the Senate, Ms. Lucius was in private practice with Jenner and Block, clerk for 2 federal judges, and served in the Office of Policy Development at the U.S. Department of Justice. She is a graduate of the University of Minnesota and the Georgetown University Law Center. Ms. Rice-Minus serves as Vice President of Government Affairs at Prison Fellowship, the nation's largest Christian nonprofit serving prisoners, former prisoners, and their families. As leader of Prison Fellowship's policy staff, Ms. Rice-Minus directs lobbying, research, and legislative campaigns on criminal justice issues at the state and federal levels. Before her tenure at Prison Fellowship, she managed advocacy efforts on behalf of the National Religious Campaign Against Torture. She is a graduate of Colorado State University and George Mason University's Antonin Scalia Law School. Ms. Jorgensen.
Good morning, Judge Pryor and members of the commission. First, I have to point out that I am also the parent of a graduate of Tulane University, recent graduate.
Very well educated.
Yes, sir. Good morning. I really appreciate, on behalf of the National Association of Assistant U.S. Attorneys, the opportunity to come before you. My first time here, but thank you very much for inviting the association to be here. We also are referred to as NAUSA, the National Association of Assistant U.S. Attorneys.
And as everyone has to have an acronym.
That's right, Judge. I'm sure you all know that NAUSA does represent the interests of about 5,400 prosecutors throughout the nation who are responsible for prosecuting federal offenses, and we will see on a daily basis the very real effects of this amendment that is being proposed. To jump right in, and I hope you'll allow me to go off script just a little bit to try to get maybe quicker to our question and answers. The proposed amendment would carve out an entirely new category. And Ms. Conrad talked about the sentencing table. Of course, we're all very familiar with that sentencing table. But this new category would almost push off the sentencing table. It would create a new category where defendants will be closer to that top left corner that they want to be in. Across the board, it would paint with such a broad brush rather than with a specific fine tip addressing the crimes where the commission feels really need to be addressed. That is our biggest objection to this. It would carve out this new reduction in sentencing guideline range, regardless of the type of offense that has been committed. You've already heard the testimony and discussed a little bit the recidivism rates. And again, I just want to echo what was said by the Department of Justice representative that we still have a recidivism rate of 30%, even for those who have zero criminal history. So it is significant. One area, as you've also heard, where this proposed amendment would wreak a special havoc is with purchasers of firearms for violent felons, straw purchasers. As we know, and as has been well documented, the majority of firearms that are used to commit these felonies are purchased through the use of a straw purchaser. And due to the need for the straw purchaser to pass a background check, they are by definition a first offender. Yet, as drafted, this broad brush amendment would not make an exception for them. and would actually reward them for having that clean criminal history that they need to commit the crime. And in some cases where you have a straw purchaser starting at a base offense level of 12, because the prosecutor may not be able to prove that the person, the defendant, knew that firearm or firearms were going to a prohibited person, you can get down as low as 12 to 18 months. And this is another further reward to those straw purchasers of those firearms. Another area where this would have a tremendous impact is white-collar crime context, where it would really provide a windfall to the offenders who commit a wide range of white-collar crime, from tax fraud to Medicare fraud, consumer targeting fraud, to public corruption. And as we all know, thanks to the recent 2017 data that's been released, actually 71% of all the fraud defendants have no criminal history. They have no prior offense. So we're going to now give them an added benefit simply because they have no prior offense. If the Commission does intend to move forward with this, we do strongly recommend that you consider using option 2, which would be purely a first offender with no criminal history, no points that are countable or otherwise. We also highly recommend that you limit this reduction to only 1 level rather than 2. The second part of this amendment, which is very difficult for our association, is the proposed amendment would go even further, providing that certain nonviolent first offenders who fall within Zone A or B would, quote, ordinarily should not receive a sentence of imprisonment. This would, again, be a very powerful prize for white-collar offenders in the current package of proposed amendments, probably the biggest windfall for them, because you would create a presumption of no jail time, which we believe would send the wrong message, not only in terms of general deterrence, but really the wrong message to the crime victims, to the people who have suffered the financial losses, sometimes ruining their financial future. And here again, I would like to just veer off script for a moment. We've heard some of the defenders talk about Section 994J, which talks about the need for non-prison sentences. But 944J does not exist in a vacuum. 944 is a very lengthy section. It gives the Commission a lot of guidance in a lot of areas. And 994I in particular says that the Commission shall assure a substantial term of imprisonment where a defendant has, number 2, committed the offense as part of a pattern of criminal conduct from which the defendant derives a substantial portion of their income. That describes a lot of fraud criminals, white-collar offenders. So you can see that 994, those two provisions may be opposed to each other in this case, and we would urge you not to paint, again, with that broad brush to reward all white-collar offenders, no matter how significant, no matter whether they've gotten an aggravating role enhancement or not, by giving them that 1 or 2 point reduction. Finally, and we've had some discussion already in the area of narcotics, over 64,000 deaths from overdoses in 2016. We urge the Commission to consider the fact that these offenders are not nonviolent, even if they don't possess a firearm during the commission of their offense. What they're doing, narcotics dealers, is affecting people in a huge way and in a violent way. Thank you very much on behalf of the National Association of Assistant U.S. Attorneys for considering our views on these important and very impactful amendments.
Ms. Lucius.
Good morning, Judge Pryor and members of the Sentencing Commission. I am the Executive Vice President for Policy at the Leadership Conference of Civil and Human Rights, a coalition charged by its diverse membership of more than 200 national organizations to promote and protect the civil and human rights of all persons in the United States. Today's hearing addresses a crucial problem within the justice system. Over the past 40 years, the American incarceration rate has ballooned to a level we can no longer maintain. This has had a disproportionate impact on communities of color. African Americans make up 13.3% of our population, but nearly 38% of the federal prison population. Hispanics account for 17.8% of our population, but nearly 33% of federal inmates. Prison facilities at all security levels are operating over capacity as a result of the overwhelming influx of people being funneled into incarceration. The Commission's proposed amendments offer a step toward addressing these issues. The Leadership Conference joins the widespread bipartisan support of the Commission's efforts to minimize costs, reduce prison overcrowding, and promote the effectiveness of reentry programs. People charged with their first criminal offense pose a substantially lower threat of recidivism, so it makes good sense to focus on this category for amendments. Expanding the availability of alternatives to incarceration for people who've committed a low-level offense for the first time achieves the Commission's statutory responsibility to guide courts towards sentences that are sufficient but not greater than necessary, and that afford adequate deterrence to criminal conduct. But we urge the Commission to adopt a broader definition of first offenders than is shown in either option 1 or 2. Instead, we believe it should include anyone in Category 1. The Commission already groups offenders with 1 and 0 criminal history points together in that category in the sentencing table, and for good reason. Chapter 4 makes clear that the differences between those with 0 or 1 criminal history points is minimal. These additional people should be eligible for relief under proposed Section 4C 1.1, given their similarity. Making offenders with 1 criminal history point eligible for the same relief as those with 0 criminal history points is consistent with the Commission's practice of treating those 2 cohorts as part of 1 criminal history category. Second, the Leadership Conference also supports the Commission's proposed amendment recommending that first offenders with an offense level under 16 receive a 2-level reduction, and all other first offenders receive a 1-level reduction. A 2-level reduction is better than 1 because it better serves the Commission's stated goals of reducing costs and overcrowding. And while we support the Commission's proposed 2-level reduction, we also encourage the Commission to extend the offense level reduction along the full offense level scale and apply multiple offense level reductions to all first offenders sentenced to 24 months or less. This change would not prevent judges from assessing the individual circumstances of each case and would still allow a higher sentence if warranted by the individual circumstances. Third, we support the creation of a rebuttable presumption in Section 5C 1.1 that first offenders who have a guideline range in zones A or B should ordinarily receive a sentence other than incarceration. This presumption would substantially advance the Commission's goals to provide the defendant correctional treatment in the most effective manner and to reduce costs, reduce overcrowding, and promote effectiveness of reentry programs. Keeping these first offenders out of prison will allow them to keep their employment and maintain their relationships with their family and their community, both of which have been shown to decrease the likelihood of recidivism. We understand that a portion of federal prosecutors represented by NAUSA and the Justice Department leadership opposes the Commission's proposal, arguing that judges already have the discretion under the current guidelines to impose sentence alternatives and vary downward under exceptional circumstances. However, the Commission itself has found that judges have been exercising that discretion less and less over the past 3 decades. Although the guidelines are technically non-binding, judges often feel compelled to apply a sentence within the range given to them, and the Sentencing Commission, through these amendments, can provide judges with additional tools to better tailor a sentence to the circumstances at hand. The resulting impact, enhanced judicial discretion, more appropriate sentences, reduced prison overcrowding, and lower costs to taxpayers speak all in strong favor of adopting your amendments. The Leadership Conference remains committed to working with the Commission to create more comprehensive and effective sentencing guidelines that operate to reduce incarceration rates for individuals with low-level offenses and promote rehabilitation. These changes represent an opportunity to mitigate excessively punitive provisions that have promoted racial disparities in sentencing and contributed to a costly explosion in our federal prison population. The voices of the civil and human rights community are important in this ongoing national conversation. Thank you for your commitment to these issues, and thanks for the opportunity to testify today.
Ms. Rice-Minus.
Thank you. Judge Pryor, members of the Sentencing Commission, thank you for the opportunity to testify today. I'm here on behalf of Prison Fellowship, the nation's largest Christian nonprofit serving prisoners and a leading advocate for criminal justice reform. The organization was founded in 1976 by Charles Colson, a former aide to President Nixon, who served a 7-month sentence for a Watergate-related crime. He used his second chance to start our ministry. Today, our prison programs reach more than 365,000 men and women each year. Our Angel Tree program provides Christmas gifts, service to over 300,000 children annually on behalf of their incarcerated moms or dads. And in terms of our impact in the federal context, 131 federal prisons participate in our Angel Tree program, and 36 federal prisons have non-intensive rehabilitative programming. Prison Fellowship is encouraged by the Sentencing Commission's focus on the use of alternatives to incarceration. Our federal prison system is currently overexceeding its capacity, so the need is a practical consideration in terms of prison safety, program delivery, and expense. However, alternatives to incarceration also promote human dignity and restoration by increasing active accountability. While retribution is a valid component of the purposes of punishment, we believe that the greatest goal of the criminal justice system should be restoration for all involved, the affected community, the victim, and the person responsible for the crime. In a recent Barna poll commissioned by Prison Fellowship, we found that 87% of Americans agree with this. Too often in the United States, our default punishment is incarceration, and too seldom do we sufficiently appreciate the benefits of thinking outside the bars. Community supervision and alternative to incarceration court programs in particular can provide just punishment for people with first-time and low-level offenses, and in some cases, more serious offenses. These alternative programs, when implemented correctly, can be even more effective than incarceration. And incarceration, while of course the ultimate loss of liberty, is arguably a passive form of accountability, compelling someone to make amends for the harm that they have caused by living differently day by day in the context of a specialty court or through community supervision is active and arguably more difficult. The Commission rightly acknowledges in its report that Congress intended alternatives of incarceration to apply to people with lower level and first-time offenses. And though Prison Fellowship would support a broader application, this population is sensible for the Commission to target for alternatives to incarceration under both the legal framework and the recidivism data. As the Sentencing Commission's reports demonstrate, prior criminal conduct is a strong predictor of recidivism. Individuals with lower total criminal history scores have lower recidivism rates. Thus, the populations contemplated in the proposed amendment options these people are not only less culpable, they present the least risk to the public safety, and they stand to greatly benefit from the ability to maintain work and family ties that will be available to them as they are held accountable in the community. While the proposed amendment specifically mentions alternatives to incarceration in the form of fines and community supervision, the Commission should also encourage other alternatives such as specialty courts. The federal system has very limited number of specialty courts and very limited data about the outcomes of people who have matriculated through these programs, and we agree with the Commission that greater resources are needed to invest in research and evaluate the outcomes of these programs. In additionally, although we acknowledge that the federal system has a unique population and offenses that limit the application, we would request that the Sentencing Commission explore the use of restorative justice programs as an additional model where appropriate, feasible, and agreed to by any involved victims. Studies that have compared restorative justice with the traditional criminal justice systems have found that restorative justice lowers repeat offending, reduces post-traumatic stress in victims, costs less, is more efficient, and leaves victims and the individuals responsible for crime more satisfied that justice was done. In addition to these requests, Prison Fellowship recommends, in reference to Part A of the proposed amendment, that the Commission adopt Option 1 with respect to the definition of first offender, so that more effective alternatives are available to the sentencing judge for defendants with no criminal history points, who we believe should not burden the already overcrowded federal prison system. We ask that you adopt Option 2 with respect to the decrease of offense level for people with first-time offenses. And finally, in reference to Part B of the proposed amendment, we ask that you maintain application to all offenses and advance the consolidation of Zones B and C. Thank you.
Thank you. Questions?
Oh, please, at least one.
You know you're hungry.
I'll ask you on the show.
There you go. Oh, you're going to regret that comment.
Let's take offenders who have no criminal history points and no prior convictions. Is there an offense level at which you think there ought to be a presumption of non-incarceration?
I would say, I would agree with the way that the table is set up. That is that where we have enhancements for things like aggravating role, where the loss is larger, where the crime is more serious, you go down the table, and then incarceration becomes more obvious. But I think as it is now, there really is a presumption of no incarceration at the very lowest levels for Category 1.
But don't you think?
Go ahead. I'd like to get an answer to my question.
Is there one specific level?
So we're just taking an offender who has no criminal history points, no prior convictions. Is there an offense level at which you think there ought to be a presumption of non-incarceration?
No, I would say no, sir. I don't believe so,
never.
because the reason is, I think every single crime and every single defendant needs to be looked at individually. And when you lay down a line like that and make a presumption that there should be no incarceration, that takes no account of what the crime is or the other factors.
Can I just ask, are you in favor of mandatory minimums?
As a general measure, yes. I'm not a narcotics prosecutor, but I do think that they have had a significant effect on reducing those crimes.
I mean,
Over the
guess
years.
in the sense of also taking away the individualization in that case. I mean, if every
Yes.
case requires an individual look, it
Well,
just would be the flip side of that.
That's true. Well, I think I was also in favor of the safety valve, though. As a young prosecutor who prosecuted those cases and watched people who had more drugs than they realized they had, having to watch them get sentenced to 10 years with no help was difficult. And I think I applaud the commission for coming up with that.
I wonder, I haven't really thought this through, that may be evident, but I would tell you that I think judges, the advantage of having a zero category, regardless of whether we attach presumptions or not, is that judges then, in their minds, would make some distinction between somebody who's never run afoul of the system and somebody who has. And therefore, in that judge's mind, they may be more inclined to go to the zero of the 0 to 6 or than not. Does DOJ, would you have any objection to that? I mean,
She doesn't represent.
I'm actually representing the members who are National
I mean, I'm just
Association, but
curious. Okay, leaving DOJ aside, but from your point of view as a prosecutor and so forth, do you think that would create any problems?
well, again, I think just by moving over now, we're going to create a category that's all by itself, where all the others have three
Well,
different
but by
levels.
virtue of saying these people actually are different. They seem to be different. I mean, we are creating the category, but the category relates to whether or not this person is the same as somebody else, because we know we have a lumping factor here.
Right.
We've taken that person and lumped that person with others.
Well, Judge, I think the fact that your own data shows across the board, judges are varying below the guidelines. I mean, there's a pretty significant band there that's below, the sentences that are given out are below the minimum.
Which suggests the guidelines not working.
Your Honor, I would say no. I would say the judges are simply applying them. They're looking at them the way they have to correctly first, and then they are taking into account the individual characteristics.
And then they're disregarding it.
Well, as a prosecutor, I would have to say yes, in many cases, yes. But getting back to your question, give you an example, a fraud case where you have a massive fraud, consumer fraud, directed at people who are losing a lot of money. Happens to happen quite a bit in the Southern District of Florida. You have a lot of different people involved. Managers may be committing this fraudulent activity for a year or two and taking $100,000 away from people. They don't have any criminal history. Most of them walk into court and they don't. But yet they have lied, they have taken financial, imposed financial hardship on people. Should we now presume that they don't get any?
That's why my question was about the offense level.
Right.
Presumably, they have a higher offense level. I just
Well,
wondered if there's an offense level at which you think there ought to be a presumption.
Yes, sir. I would say no. I mean, if there was one, it would probably be 6. But you have to be a fairly minor participant. A lot of things have to happen to get down that low in a federal case.
For smaller losses. I mean, you go through the loss table and you
Right.
see, when I went through the loss table, I was looking at somebody could, if you do all the way in zone A, I mean, you might get up to less than $500,000. It's some large number. I don't know, 500, 250, I don't know what the number
It is.
But those are big losses by anybody's, and especially a big loss in terms of maybe in terms of number of victims, or in terms of life savings, or in terms of real harm that can be caused. So I'm interested actually in Judge Pryor's question to you. I mean, why wouldn't you at least set some level? Maybe it's 6, maybe it's 4, and say, look, as to those people, maybe they should be treated differently. But you don't think so?
Well, Judge, that's not the question before the commission right now, but I would hesitate to endorse such a broad brush, of just saying one offense level below which people should simply not go to jail.
Question was a presumption.
A presumption, yes.
It would allow, any presumption could be rebutted, right?
Right.
And you would,
I would disagree with it. Yes, Judge, I would.
Judge Reed.
Just one follow-up, getting back to the question about subjectivity of the judge and what he's thinking about. Have you ever had a case in which a defendant is in criminal history category 1 with no criminal history, in which the defendant's attorney is not argued, look at his criminal history, it's nothing? Please
Right.
take that into account.
That's correct.
Have you ever had a case in which that's not occurred? I
No, sir.
haven't.
No. I mean, it is, and most of the time, it results in a variance. I mean, that's the
But you
fact.
see, we're trying to get away. I think, maybe we'll get unanimity on it. I think we're trying to get away from variances. We're trying to have guidelines that are heartland guidelines and that judges will embrace. And because for a variety of reasons. Disparity, all across the country. I mean, that's why, even though you didn't ask for any questions, I would just say, while you may be correct in everything you say, and I understand it, and I appreciate it, I don't know that you've answered the question about general deterrence. And I understand your views in confinement and incarceration, but I must say that what hits me as one commissioner is, will we achieve general deterrence by simply saying, look, first time, it's under a certain amount, maybe it's under $500,000, you get probation. And that's what concerns me, and I'm not asking you a question. I mean,
If we can, I'd like to wrap this up. We've gone considerably over today, but we appreciate your testimony today, and we, of course, have your written testimony. That concludes our public hearing today. I should have asked, unless Commissioner Belatho, if he can speak, has a question.
He could text, I guess.
He hasn't had any questions. He could text one, I guess. Okay, thank you very much.